As I shared at the top of the program, this morning the U.S. Supreme Court released a bombshell decision in the case concerning presidential immunity, specifically as it relates to former President Trump. This is a huge issue. We've had people wanting to have this thing dissected and explain what it means, and I'm happy to say that here now to break all this down for us is Phill Kline. He's Associate Professor of Law at Liberty University and is the former Attorney General for the great state of Kansas and former District Attorney for Johnson County. Philip, welcome back to Washington Watch. Always great to have you.
Good to be with you, Congressman.
All right, so let's get down to it in layman's terms. Let's start here in layman's terms. What did the court decide in the Trump immunity case?
Well, they basically reinforced a long-standing notion of the separation of powers in the United States, and basically stating that a president, in the exercise of his constitutional and statutory responsibilities, needs to be immune from zealous or overreaching oversight by the other branches of government, including that of Congress and even the courts, as well as a prosecutor who might take a law and try to weaponize it against the president to try to deter certain behavior. A president cannot make the decisions that he or she needs to make if there's what's called the pall of prosecution hanging over them. The president makes numerous decisions every day which dramatically impact individuals and others. And if he was subject to civil litigation or criminal prosecution for any decision that he makes, then he would be reticent to make the decisions he needs to make. So the court recognized that. And it's fascinating, Congressman, to look at the position of the Biden Justice Department in this case, because they essentially said that the president's not immune from anything that could be considered a crime. And right now, if you look at how the Justice Department is interpreting laws, almost anything, when combined with all the laws that have been passed, could be a crime. And that the Justice Department said that we ought to consider the motive of the president in determining whether it's a crime, and that President Trump had the motive to stay in power. Well, let's take a look at Biden right now. Biden has repeatedly been told by federal courts, including the United States Supreme Court, that his loan forgiveness program is illegal. He doesn't have the authority to do it. Yet he persists in the face of court orders to try to do the student loan forgiveness program. And I believe part of his motive is re-election. So under the Justice Department interpretation, Biden could be prosecuted for his insistence on student loan forgiveness. It's insane today in America how this party is willing to interpret the law to target its enemies and to maintain its own authority. And this is exactly the type of thing that presidential immunity is designed to guard against. And that's basically what the court said.
That is an excellent example with the student loan thing. I have not connected those dots, and that just makes all the sense in the world. I think that'll be extremely helpful to our viewers and listeners as well to just have an up-to-date what's happening right now is right in line with this whole decision. So with the Supreme Court decision, did they differentiate between what counts as an official act versus a personal act?
Well, they gave a little bit of guidance, and they say that it's very factual intensive. If it is an official act of the president, it is within his authority granted by law, then that affords him, in certain instances, absolute immunity under its constitutional authority, like President Trump's communications with his own Justice Department, President Trump working with Mr. Pence when he was vice president. All of that, the court has determined he is granted right now absolute immunity. So all of that evidence can't even be used to support the other crimes based upon this court decision, because you can't predicate an indictment based upon conduct for which the president is immune. That calls into question, by the way, the initial indictment in its entirety, because Jack Smith introduced all that evidence to the grand jury to obtain an indictment. And as the court states in its 6-3 decision, you can't use conduct for which the president is immune to justify or to help support an indictment in its entirety. So there's some real questions there. But additionally, any president is allowed to have a presumption of immunity in certain of all official acts. And that presumption is a real high burden for the government to meet. It must show that the government's prosecution would have no impact on the president exercising his responsibilities. That is extraordinarily hard to prove, if not impossible to prove, especially in this context. Now, the court remanded the case to the lower court to determine whether the president was engaged in official or unofficial acts. There is no immunity for unofficial acts. So we have to look at what remains in the indictment and assess the facts surrounding that to determine if President Trump, in his communication with state legislators, with governors, with secretaries of state, expressing his concerns about the election, and in trying to get those states to reconsider their certification, were unofficial acts. So the issue then becomes whether it was of a legitimate public concern for the president to speak into election integrity. Well, Congressman, there have been hundreds of laws passed and amended since 2020 because of concerns about the 2020 election. It is undisputed that in 2020, numerous laws were broken, that there was an unprecedented impact that still hasn't been measured of private monies going directly into election offices. There have been numerous court findings that much of the conduct of the 2020 election was against the law. For example, drop boxes were illegal in Wisconsin. For example, in Michigan, it's been found since the 2020 election that the Michigan Secretary of State's guidance on how you determine signature matches was illegal guidance. In Pennsylvania, you had illegal ballot harvesting. So to say that the president speaking into those concerns is an unofficial act when Congress, Democratic congressmen, President Biden himself has addressed election integrity and proposed bills regarding it since 2020, I think is illogical. So I believe the D.C. Circuit Court is rather trapped in this if they read this decision carefully, but it is clear this Supreme Court will not uphold this prosecution if it comes back to them under this set of facts claiming that the president was engaged in unofficial activity.
That's fascinating. So this is what you just described is what makes this a bombshell case against the Jack Smith case of former President Trump. If I can, our time's slipping away. I'd like to get to another topic, but it keeps running down this same general path. The Democrats are now obviously considering their political options after the disastrous debate that Joe Biden had with President Trump. A question that keeps coming up over and over and over, can they, the Democrats, can they legally replace President Joe Biden on the ballot at this point, at this stage in the game?
Yes, they can. And let me come back to that in just a moment, adding one more thing about this immunity, Congressman. The Supreme Court really sent a message directly to Jack Smith because in rejecting his approach under the law in this case, it quoted the last time he was before the U.S. Supreme Court in a prosecution of a former Virginia governor in which he lost 9-0. And the court basically said, you are undermining democracy in your approach in contorting the laws to forge your prosecution. Wow. And it quoted from that case. So it was a direct message. The Democratic Party rules allow for their delegates to vote based on their conscience at the Democratic Convention. That rule was changed in 1982 to allow them to do so. So they're not strictly beholden to President Biden and his nomination. They can change it. Most likely, if Mr. Biden is to be replaced, it would involve a withdrawal of his candidacy, which would free those delegates naturally, and they could select somebody to replace him. If he withdraws after the convention and after he receives the nomination, the Democratic rules allow the Democratic Party, the DNC, in consultation with Democratic governors in Congress, to replace him on the nomination as the Democratic nominee. So they are capable of doing it. The rules allow it to happen. It's a difficult process because the Democratic Party has some factionalism built into their superdelegate numbers at their convention. So these interest groups have specific and higher authority to impact who might replace Biden on the ticket. And of course, they have the natural presumptive nominee in the vice president, in Ms. Harris, that many of the Democrat delegates do not want to support as an alternative. So it's messy, but it can be done legally.
Okay, so what about, I mean, the whole process of any election and the primary part of it, I mean, particularly for President of the United States, so running for office for a couple of years involved in the campaign, and that's all about the voters being able to vet the candidates, to get to know the candidates, to know what they believe, this, that, the other. States have primary elections, so the nominee is in that role based upon the votes of the party that's selecting them. So could some disgruntled Democrats who voted for Biden during the primaries, could they potentially sue a new Democratic candidate for president if someone else were nominated?
Well, unfortunately, in America today, almost anybody can sue, and you can also find a court to accept the lawsuit. But the party rules are pretty clear, and this has also been the history of our presidential nominating conventions, and that is those party rules determine, and states in the past, almost all states have allowed the parties to determine the method to select their nominees. Now, interestingly, the Democrats have been fighting to change state law so that party rule is not available to them. For example, here in Virginia, the Democrats have successfully changed the law to not allow closed primaries, or the Republican primary, to prevent others from participating. So there is some effort to change this, but right now in America, generally, the party gets to select its nominee. And these delegates are selected based on a pledge to support Mr. Biden. So voters voted for those delegates, much like presidential electors. And they voted for these delegates. These delegates pledged to vote for Biden. And party rules now say they can vote their conscience, so that even though they made the pledge to Biden, if their conscience somehow dictates they should vote otherwise, they can, even without a formal release.
Well, it sounds like it's going to be a huge mess, and I'm sorry we've got less than a minute left here, but there are some states that already have Biden on the ballot. They can't change that, from my understanding. You've got the 25th Amendment coming up. You've got the possibility of the president stepping down before this. Is it going to get messier before it ever gets cleaned up?
Well, it's already messy. And then you also have, Congressman, you have the money. I think President Biden is sitting on $30 or $50 million, and those funds can't be transferred to any other candidate but the vice president. And otherwise, they go to a super PAC or a charity, a nonprofit, and there are many, unfortunately, leftist partisan nonprofits that could accept these monies and impact the election. So it is already messy, and it's going to be fascinating to watch. Yep.
Thank you, Phill Kline, Associate Professor of Law at Liberty University. Always great to have you on the program.